Napa County land use update. We thought there's been a lot going on. There's a lot coming up in terms of changes to various regulations, and we thought it would be helpful to do a sort of omnibus presentation about everything that's been going on and tell you what we know and what we've observed. So if we can turn to what we're going to cover, a brief note on the code compliance program and where that's at, a little bit about experiences with the winery streamlining ordinance now that we're a year or so into that, some talk about the new micro winery ordinance, which was recently adopted, some talk about the proposed residential building envelope ordinance in the county, this sort of McMansion limiting ordinance, as it's been referred to. And then at the state level, pending legislation before the Board of Forestry, which I'm sure you all know about. It's been going on for over a year now. We just got the latest iteration of the proposed regulations from the state, and that comment period is coming up and closing next week. So it's particularly timely. So if we go on to our next page, the code compliance program, as you know, there was a deadline in March of 2019 by which time wineries were supposed to file if they were out of compliance with their permits and have an opportunity to bring themselves back into compliance. The carrot that was associated with that program was that you were allowed to continue to operate out of compliance while they processed your use permit. So the result is that there are a few wineries still left that have not finished that. And the county is starting to get irritated and treat them. I put malingerers in quotes because the county's attitude is that people are deliberately dragging their heels because they're benefiting from being able to operate out of compliance without having to make whatever infrastructure improvements might be required as a condition of approval when they get their permit. I don't think that's a completely fair characterization. The reality is that it was the processing time on the compliance program was very slow, and the county itself took a long time to get back to people, particularly because, as I mentioned here, there's a lot of new staff and a lot of the people who knew a lot about winery use permits either have retired or are in different departments, et cetera. So I think the main point here is if you are one of the few wineries who is still being processed under that program, you probably want to appear to be as proactive as possible in getting through, because I worry that for the few remaining wineries that the county is going to start being more punitive in their attitude towards them, and that will then have repercussions for whether or not all the requests in the use permit are granted. So I think that's the important thing. In terms of the program as a whole, I don't know that I have thoughts about whether I think it was a success or not. I think many wineries were frustrated with the characterization of the rights under their permit. But I think generally for those who did make it through the program, I suppose the benefit is now that they have a settled use permit and they can move forward from there. So if we go to the next page, let's talk a little bit about the streamline ordinance. The goal is, as you remember, was to give wineries an easier method to either convert small winery exemptions into use permits. Small winery exemptions were the sort of over-the-counter permits from the 80s that allowed you to have a winery of up to 20,000 gallons production capacity with no visitors. Many people had operated under those for many years. They had visitors. They sometimes were out of compliance in other ways. And there was a desire to bring those under use permit. There was also a desire to clarify, to expand what was counted as a minor modification and could be handled at the administrative level without a full hearing before the Planning Commission. And that was sorely needed. So that ordinance was effective March of 2020, right in time for the lockdowns. It allowed, as I said, small wineries to convert to use permit, small winery exemptions. It allowed a wide variety of different types of changes, and we'll talk about some of those, that would count as a minor modification. And then it streamlined the process for getting a modification if you were in the industrial area and the business park. So go to the next slide. I have been processing some applications using the streamline ordinance, and I've noticed a few things that I wanted to mention to you. Let me grab my code book. One is that there is an ambiguity regarding employee numbers. So one of the things that wineries are often out of compliance with is employee numbers, because often, when they filed for the original permit, they said we have 2 employees or no employees. And then, of course, over the years, things have changed considerably. The county approach was to put in subsection 1, this is of 18-124-130 of the Napa County Code. So subsection C(1) says a minor mod for any increase in the number of full-time equivalent existing permitted employees up to a total of 10 employees or by up to 10%, whichever is greater. Now, this is great. That means if you're a small winery and you're permitted to have 2 employees, you can go up to 10. If you're a large winery and you have 50 employees, that means you can add 5. So it's a pretty good and flexible number. The problem comes with subsection 2, which says any increase in the number of full-time equivalent existing permitted employees, number 2, tours and tastings, or number 3, deliveries, such that the total number of vehicle trips for all such uses on the property does not exceed 40 average daily trips or 20 daily round trips. So the concern about that is if you are increasing, does the 40 ADT limit in subsection 2 apply to subsection 1? And if so, it's a huge problem because larger wineries already have more than 40 ADT. They have many more trips per day. In fact, most wineries have more than 40 trips per day. For now, I'm treating it as if they are separate subsections and as if if you are applying to be up to 10 employees or 10% increase in employees, as if the 40 ADT does not apply to you, but that's not at all clear. And none of my projects is far enough along for it to be clear that the county is going to agree with that interpretation. The second thing that I've noticed is that it's unclear whether if you apply to make all of the changes allowed in the code. So it's increase in employees, increase in tours and tastings, increase in production up to 30,000 gallons, an increase in the number of marketing events up to a total of 11, change in the days of operation, change in your building footprint by up to 25% in size, and the addition of a new full commercial kitchen where you just had a mini kitchen before. So those are the 7 categories. If you ask to do all of those things, will the county still process it as a minor modification, or will they say that cumulatively that there are now so many changes that it kicks over into a major modification and it should go before the commission? I don't know the answer to that. I'm hoping that you can make all of these changes and still be a minor modification, but I think there will be some question probably on a case-by-case basis, so that if it looks like it's too big a change, and this would apply more to small wineries than large ones, where it looked like the cumulative impact of all of these changes might be bigger, I'm concerned that they might kick it to the commission. The third thing on this list is the effect of successive applications. There is no, we'll talk about it when we talk about micro wineries. There's a 2-year limit. It says if you apply for a micro winery, you can't come back and apply to convert it to a macro winery for 2 years. I think it's 2 years. There's no similar provision in the streamline ordinance. So if you do a minor mod, can you come back a year later and do another minor mod and another and another? And will the county again say at some point the effect of the successive applications is that it should be a major mod? I suppose on the one hand, if you're willing to serially go through the minor modification process and all the angst associated with that, maybe the county will let you, but I think it's an open question. And the last issue is the most important. RSS stands for Road and Street Standards. The same subsection C that I talked about has a sentence that says, minor modifications will not trigger application of the Napa County Road and Street Standards unless the total ADT from all uses exceeds 40 ADT or the inspection authority determines that improvements are required to comply with the state. You don't need to worry about the rest of that. But unless the total ADT from all uses exceeds 40, it does not say, is it all uses on the property or all uses on the road? And the problem that we're running into is that for wineries that are on private roads or shared driveways, that the county wants to interpret it as meaning 40 ADT on the road as a whole, not 40 ADT generated by the winery. And that's problematic because I'm sure many of you are familiar with the fact that the county assumes that a residence de facto generates 10 average daily trips per day. So if you have a shared driveway with, let's say, 4 parcels, even without your winery, you are automatically at 40 ADT. And so I think that what we will see is that this ordinance should come back to the Board of Supervisors and be tweaked. And we would like to see it tweaked to say it's 40 ADT on the winery property, or better yet, 40 ADT associated with the winery uses on the property and not anything else. We just submitted a letter to the Board of Supervisors for today's hearing in association with the Board of Forestry for one of our clients to that effect. I think it's important because for smaller wineries or even larger wineries on private roads or on shared driveways, this is going to be a significant hindrance because road improvements, as you know, can be prohibitively expensive, particularly anywhere in the hills. So I think that's something to be aware of if you are thinking of doing a minor modification. Don't assume that because you fall into the minor mod category that you're going to be exempt from road improvements. It's not clear. The same is true for small winery exemptions. Converting to use permit are running into that problem as well. So I think that's everything I wanted to say about the streamlined ordinance. The next issue, which I'll introduce and then Rick will take over, is the micro winery ordinance. So as you know, this was started by a number of growers who had owned vineyard land, but did not have their own winery facilities. They were alternating proprietors at someone else's facility. So they were fully bonded wineries. They had a type 02 wine grower's license from the ABC, but they did not have their own facility. And they were finding that either they didn't have tasting privileges at the winery, or that it wasn't the tasting experience that they wanted for their customers because it didn't give the customers any sense of the land from which this wine came. And they wanted the ability to bring people to their property so that their customers could experience the vineyard land, which is a very important goal. I got involved a bit and was consulted early on in this process, and I actually suggested that I thought the approach to this should be to push the county to allow for off-site tasting rooms, what's called the duplicate 02 in ABC parlance. That is the sort of tasting room that you see in the cities, where it's just a tasting room. There's no meals, there's no wine served, there's no wine reproduction going on. It's just a tasting room. Those are not currently allowed in the county. The county considers that it's not an accessory agricultural use if it's not attached to a production facility. But they did once upon a time allow it, and there are a few grandfathered offsite tasting rooms. And the most obvious one that comes to mind is Heights, the facility on Highway 29. But the county has for some time not allowed duplicate O2s. I thought that would be the easiest, would be to say you can have a small building, say 500 square feet. You can have some visitors. There's no production. There's no marketing events. There's no food service. It's just come visit the property, have a taste of the wine and buy some wine, similar to the fruit stands that we see around the county. That is not the route that they went. Instead, they said we would have a micro production facility. So there would be a sort of tiny amount of fermentation and production happening on the site. And that would be sufficient to support a modest amount of visitation. And the great news is that the Family Farms Initiative did very good work, and they got that all the way through. They got the political support, and that was adopted. We're now seeing people who are considering applying for micro winery permits. And so we wanted to talk to you a little bit about the specifics of what's involved and what the constraints on those are. So Rick, why don't I turn it over to you for that?
Thanks, Kay. Appreciate it. And good morning, everybody. So yes, basically process and requirements to qualify for micro winery ordinance. Let's start with the process. Similar to what Kay was mentioning about streamlining, the micro winery applications would go through a streamlined process, which means it's approved administratively, staff level approval. They have what's called a zoning administrator process. They meet in their office. Rarely does anybody show but an applicant. If there are some folks who are concerned about it, neighbors, perhaps they show, but the process is indeed streamlined relative to the lack of formality that you see, say, with the Planning Commission or Board of Supervisors meeting. Notice is similar to all other applications. It's submitted to property owners within 1,000 feet of the project site. There's a list of people who kind of mine projects that occur here in the county. And so notice is provided to them. And it's also placed on a website that the county will show to the public for those people who are interested. Unlike what used to be the case, or what is the case for more major use permits, which is to put information notices in the newspaper. The public hearing, like I say, is conducted by the zoning administrator, and once action is taken, a letter goes out, conditions of approval, which have already been reviewed by the applicant and available to the public, is set, and that final action is determined. It's still an appealable action. So an aggrieved party could file an appeal within 10 working days, I believe the time is, which would be then reviewed by the Board of Supervisors if there was an appeal. So the process is indeed streamlined. It takes approximately a year. It could be less. It often is more. We haven't tested the micro winery ordinance yet, but for similar projects, it's taking about that long for a variety of reasons, including as staff, as Kay mentioned, the staff shortfall that is continually hindering the county. In terms of general requirements, there's a minimum and a maximum annual production of products. So that's 201 gallons on the minimum side, 5,000 gallons per year on the maximum. The grapes would be 75% processed from on-site grow or adjacent contiguous properties as well. No more than 5,000 square feet of space can be enclosed or covered. So that's going to include your winery building, your hospitality, anything public is going to require accessibility standards, such as for your restrooms. It includes caves, and it includes your covered crush pad area. So a maximum of 5,000 square feet, which is substantially smaller than you'd see on other types of winery projects. No marketing events are allowed, no luncheons, no evening dinners are allowed in micro wineries, but the operational hours are similar to what would be presented in many other types of wineries. So 7 days a week between 9 a.m. and 5 p.m. The million-dollar question always is tours and tastings. How many visitors can I have in this micro winery? The next slide is intended to kind of break down how that would work. The micro winery ordinance establishes not more than 10 trips, vehicle trips to the winery, and 10 returning from the winery. So that's a total of 20 visitor trips. That's how the county would determine visitor activity. There's a standard methodology that's applied. So when an application is submitted for a micro winery, they fill out what's called a trip generation worksheet. And that worksheet establishes a number of occupants per vehicle. So 2.6 persons per vehicle on weekdays, it's 2.8 on weekends. So if you start doing the math, when you consider maybe you have 1 or 2 employees, you're going to have a small amount of deliveries, that micro winery is about able to accommodate around 12 visitors per day. that may or may not be what is of interest to applicants or the clients you're working with, but about 12 per day. There is an alternative approach that the county is aware of. You'll remember that the basis for these micro wineries was really intended to be relatively small, small growers who needed a small number of direct-to-consumers, visitors to come in. So the 12 really fits the bill. As an alternative, however, what the county has expressed some initial interest to accept is a traffic consultant, a transportation consultant can prepare a report, an evaluation that establishes that a particular winery, perhaps it is different than 2.6 persons per vehicle, that maybe larger format vehicles, limos, vans, bringing 10 people up at a time. So fewer trips, but larger numbers of people in vehicles works for this particular micro winery. And in that particular case, maybe you can get 20 a day or 30 a day. So the county's aware of this process. They're initially receptive to it. It throws into question how it'll be received by neighbors and others who bird dog what's going on in the county about, wasn't this supposed to be small? And we're seeing projects that include more people, but fewer trips. So it's something that, we want to be, we want to continually monitor and see how that works. Kay mentioned this earlier, but it's important, is that once you do receive a micro winery permit, you have to wait 2 years to make any amendments to that. And those amendments could include adding employees up to the numbers that we talked about earlier, which is, how many trips can be accommodated on site, maybe increase in production up to 5,000 square feet. So that kind of is a sense of where the regulations are in the process. The question is the micro winery right for you? And Kay, you wanted to speak to this issue.
Yes, I wanted to say something about that, because we've gone through the analysis now for a couple of clients about should they apply for a micro winery. And I think it looks fabulous on paper, but I have concerns because each component of the winery has infrastructure improvements associated with them. And although they are smaller than for a full winery, they are still requirements. So for example, you need to have a process wastewater system. You'll need to have a domestic wastewater system for your visitors. You're going to need to have a road, all the issues associated with the road standards. You need ADA compliance. You'll need some sort of building. And so although all of these will be, as I say, smaller than they would be for a full-sized winery, you don't get any economy of scale. A septic system, has a certain base cost associated with it. And I'm concerned that micro wineries are just not really economically feasible for many people, particularly the sort of small family farmers that they were intended to help. So I think it's worth, if you are thinking of applying for a micro winery, I think it's worth working with your engineers and your architect and your team to make sure that you fully understand all the costs that could be involved. And secondly, that you have a well-developed business plan so that you know that these smaller scale investments are going to work for you long time, and they're not going to have to turn around in a few years and expand everything. So it could be great for many people, but my own experience has been, I've not seen who those people are yet, I guess, is the simple conclusion there.
So the next thing we want to talk a little bit about is not existing ordinances like Streamline and micro winery, but some potential future regulations that are in the works. And one of those is called the 1 Acre Residential Development Envelope Ordinance. As you all know about Napa, agriculture is king. The interest in promoting, preserving, and enhancing agricultural opportunities and preserving wetlands and open space is really, really important, probably a fundamental goal of the counties, the board of supervisors, and the communities. It's really representative of the unique quality of life that is Napa. What has been increasingly a concern on the part of some leadership, certainly some, I suppose, in the community as well, but the board of supervisors in particular, is that they're seeing folks come in, maybe purchasing property that may not have the same vested interest that the community has through its adoption of ag protection regulations, policies for what's been now almost 50 years, measures J and P that were adopted by local voters to protect ag. And they're also seeing that development, particularly residential or non-ag development, is spreading out on property quite a bit. It's getting, from a scale perspective, large, and they're worried about it. You mentioned the word mansionization earlier, and it's what is expressed as a concern by some, like I say, in the community and the Board of Supervisors. So what this 1 acre ordinance could do is essentially what it would establish. We go to the next slide. Is it would set aside an area, it would demarcate 1 acre on a property. That could be 10, it could be 20 or larger, but 1 acre would be set aside for where residential development could occur. And that development would include your house, maybe your garage, maybe a guest house, pool house, would include the accessory elements to the home. So your patios, your decks, your bocce balls, the things like sports courts that I think were things that the county was concerned about, too much development. It would set that all into 1 acre. And some improvements wouldn't be counted. So your driveway to access the residential, whether it's a road or driveway, your wells or your natural water features that might exist on site. And it would exempt agricultural uses. So no vineyards, barns, or wineries, those kind of uses, which are so important to the county, wouldn't be counted in this 1 acre area. So for parcels that are already 1 acre, and there's some that are 1 acre in size or less, those wouldn't apply, obviously. For those that actually have residential development spread over larger spaces, perhaps over 1 acre, or in areas that are non-contiguous to one another that add up to more than 1 acre, those would apply. The challenge would be expansions in the future. There'd be pretty significant restrictions in your ability to really pierce those envelopes or the development area where residential would occur. You're not allowed to, in establishing the 1 acre envelope, to establish multiple smaller, say, 1/4 acre or 1/2 acre areas to add up to 1 acre. They want it consolidated into a single space, but they will provide exceptions where there are geographic issues like creeks, slopes, historic properties. So they might allow some deviation to the standards. And then also know that what they're seeking to do is to try to lock this on title through protective easements or some kind of permanent deed restriction so that it's known in the future for future buyers, property owners, that there is this protection mechanism for development in play. The development, there are issues that are associated with this that we're not certain how they'll play out. The plan is to work through this for the rest of this year, maybe with an approval by the end of the year. But the issues for consideration are what kinds of projects would trigger this. Are they small, like simply a bedroom addition, or maybe not the house at all, but putting converting an attic above a garage as an example? Would that trigger it? If it does, what essentially would happen is through that application, whether it's some kind of use permit application or building permit application, that's where the county would say, okay, let's identify on your plan set where that 1 acre will be. 1 acre will be, or if it's non-contiguous, where they are, and start to try to control that. Are ADUs going to be exempt? ADUs are a state mandated program. We're not certain if they'll be exempt. Leadership is changing. 2 of the 5 board supervisors are actually retiring out. And one of those supervisors was really the sponsor of this issue up Valley, say from Yountville up. And if she's, as we know, stepping down, will her elected replacement be as keen to this idea? We just don't know. The other considerations are, of course, when you tighten a development into a 1 acre area that perhaps was larger or at least was intended to be spread out, it can create more mass. Buildings go up because the area is a little bit tighter. That's not the intent. And if it's really about scale and mass, about mansionization, maybe they should be looking at other things. So these are kind of the examples of issues that we need to work through. And the next slide is intended just to simply say that there will be stakeholder meetings. There have been some. Many of us didn't know about it until regular contacts to say, oh, we want to be involved in this. But we understand by the end of the year is when they want to bring this to the board for consideration of adoption or perhaps not.
And I wanted to say before we move on to the Board of Forestry, the city of St. Helena, some of you know, I was the planning commissioner for St. Helena for years and years. St. Helena has always had something similar in its woodland and watershed zoning district, which is the area up above Meadowood. And there it's a 20,000 square foot building envelope. And my recollection is that that's simply designated with the city, and that it's not done or on a map and recorded, but it's not done through any sort of a protective easement. I would be wary of having some sort of limitation on title. I think it can be done in a much simpler method where you with the local agency, the county in this case, and then if it changes in the future, that can go through administrative approval, and it can be the building envelope can change so long as it's no longer more than 1 acre. So I don't like the idea of it going on title. I think that will just add unnecessary complication and legal hassle. And I'm particularly thinking of people with lenders who won't be familiar with what this is, and it could cause impediments if you have to get sign off from your lender in order to have this recorded, or if you're trying to get a loan and you have one of these on your property. So Sarah, that's directed to you at SVB and all the other bankers out there. I think you'd prefer not to have that sort of thing show up on title. She says agreed. So we'll push back with the county on that, and we'll use St. Helena, I think, as an example.
So the next time we want to talk about has to do with something that's probably a lot more, as you've been following this, developed in the 1 acre ordinance. The state, as most of you know, is responsible through the Department of Forestry and Fire Protection and the Board of Forestry for adopting regulations for fire protection of development, largely in state responsibility areas, local responsibility areas for high fire severity zones. And this operations, they say the structure of the department really includes the state fire marshal and CAL FIRE. And that's important to know because these kind of standards aren't really local. They can be frustrating for folks who help applicants go through a process, because often there's a disconnect between what is required and what's going on geographically in a particular region. It's also important to recognize that the CAL FIRE operates 36 of 58 county fire departments, including in Napa. So that disconnect is really something that we struggle with frequently. What's occurring at the state right now, based on, with the next slide, a recognition of a lot of things that are going on. Climate change, management of fire forests. We're seeing increasingly more severe fires. We've seen that in 2017, 2020 here in Napa. It's really been occurring for the last 20 years. We've forgotten so long ago about fires like in Santa Barbara, and then the resulting mudslides that were so devastating that were, 2 decades ago by now. So in any event, it's understood that we really need to harden our structures to protect land, protect structures, and protect lives. The question is how to do that in a way that's reasonable, and that's not one size fits all. A Napa example here is the first round. The board has been doing this for 3 years, or actually 2 years. They've released 3 versions of these draft regulations. The first set established something that was quite draconian. What it said was, if you add a single bedroom to a single family house, i.e. allowing more people to live under the roof, intensifying the numbers of people on land, that applicant would not only have to improve the road or the driveway that leads to that existing home, but they'd have to upgrade all of the access of that road and driveway all the way down to a complying road. So if you're 1 mile up off the Silverado Trail and there's multiple land uses that connect up to that road, that single homeowner adding a bedroom would be responsible for improving the entirety of that road if it didn't comply. That's cost prohibitive. It would essentially squelch all reasonable small developments, certainly single family development. The good news is the version that was released about a week ago, where comments are to be received by the state on the 27th, on May 27th, is far less draconian, certainly for residential development. For commercial development or wineries, for instance, it's still difficult, where additions would not only have to include road improvements on site, but if the complying road to the winery or the non-residential use is a great distance and it's not to code, it still would be required to be updated. So what I'd like to do is turn this over to Rachel. We'll talk about which projects trigger these standards and what are the standards generally.
Sure. Well, hello, everyone. Glad you could all make it. We're going to talk about the applicability of these new regulations, what the proposed regulations actually say in this version, and then end everything off with discussing some issues of concern. So jumping off of where Rick was before I keep going, new construction, I just want to start there, does exclude residential remodels. But it would not exclude new and extended roads. So new construction building permits there would still be triggering these new regulations, but it excludes existing, like improvements to existing buildings. So now let's start back at the top. New parcels and subdivision maps would trigger these regulations. Applications for use permits that propose an intensity or density increase, and zoning changes that you're changing zoning and you're increasing the intensity density. Those would trigger these regulations as well. Let's see what else. Triggers for exemptions. They're allowing exemptions. The original drafts had you apply at the state level. Now it's back in the local jurisdiction's hands, and the same overall practical effect would have to be met for any exemptions or exceptions they'd be granting here. Proposed development regulations, looking at driveways, they've defined driveways as serving 4 residential units. In previous iterations, they had qualified it to a certain number of parcels. I believe it was 2 in previous versions. And now they're just clarifying 4 residential units and leaving the parcels silent. Driveways are required or expected to be 10-foot wide lanes with 2-foot shoulders on each side. The turnarounds required for driveways are for any driveway over 300 feet long, and the turnaround should be within 50 feet of that building at the end of the driveway. As far as turnouts are required, any driveway between 150 and 800 feet, there's expected to be at least 1 turnout about the midway point, and for any driveways over 800 feet, you must provide turnouts at least every 400 feet. So moving on to road design standards, 2-lane roads are expected to have 2-foot wide traffic lanes, not including shoulders. The shoulders would be 2 feet wide, so it'd be a 22-foot wide road for 2-lane roads. 1-lane roads are acceptable. They could be approved by the local jurisdiction. However, with some regulations there, they must be 12 feet wide, 2-foot shoulders, and may not be longer than half a mile. They're expected to have a turnout at the midpoint for that 1-lane road, and that 1-lane road must meet a 2-lane road on each end in order to be approved. Dead-end roads are include cul-de-sacs and loop roads in this version, and the qualification is that they cannot be longer than a mile, and that is for parcels zoned over 20 acres or larger. At their terminus, they also have to have turnarounds, either a turning radius of 40 feet, or if you're installing a hammerhead, it should be 60 feet in length. Let's see. And then our probably the hottest topic, ridge lines, which is definitely a hot topic for Napa County as well. It was included in the Board of Supervisors letter, or will be included in the Napa County Board of Supervisors letter to the Board of Forestry, some comments on that. Right now, the regulations are requiring or stating that no development should occur on currently undeveloped ridgelines, and that means any structure that supports sheltering or any use of occupancy would be prohibited from being developed in the future, and that it's the local jurisdictions. They're asking the local jurisdictions to identify strategic ridgelines that would help prevent and fight fires in the event of one. This is an item that we absolutely know many of you are concerned about, and we don't necessarily, in Napa County doesn't necessarily agree that all undeveloped ridgelines are strategic, and that is something, as I mentioned, they have written in their letter, and we just wanted to bring to your attention. So, talking about issues, we are now on our last slide. Let's see. The wording is still subject to interpretation and conflicts. Some things are still unclear, such as the types of projects that would trigger these regulations. We're not sure if ADUs, if guest cottages, or if fire reconstruction projects would trigger these regulations. And that's important because in Napa County alone, over 1,300 homes burned or have been destroyed since the 2017 fires, and about 900 of them have not even filed for rebuilding. So that getting that clarification is going to be important, and we don't know if they will trigger these regulations. The language is also confusing. If it will restrict development on existing roads, will existing roads that already exceed these regulations prohibit development at the end of them, or will they be required to improve the entire road as well? And then, as we discussed, ridgelines, agriculture, every county may define agriculture differently, and its recognition as a green belt or a fuel break in terms of fire defensive strategies. At least in Napa County, vineyards would qualify as agriculture and is recognized to be a green belt, but that would be different throughout the state. So these are just some issues of concern we have and wanted to discuss, and I think.
And I would just add one point, if I could, Rachel, too. So on the residential side, for those who get into the details of road width, shoulder width, pitch, slope, those kind of things, the reality is these regulations have come a long way. And so what's existing on the books now in the county's road and street standards is essentially the same with minor variations. The big issue really happens to be the focus on the non-residential and the continued efforts by the state, and for that matter, the county also does this, is to make improvements off-site down all the way to that complying road. Where it exists now is the county, you work together and maybe they hit critical points that need improvements. The way the state standards are written now, if approved, the county may not have much flexibility, and the entirety of those roads for non-residential construction may have to be improved if indeed they are less than compliant down to, say, a Silverado Trail or a Highway 29, a complying road. So that's the issue that I think is the most concerning in this state process to update its regulations.
Okay, would you like to add anything on this? Or
I also think the ridgeline issue is of concern. You know, ridgelines operate often as important fire breaks, and so it's not clear to me why development on ridgelines would be such a problem. And also, you know, Napa has a very well developed set of regulations in the viewshed ordinance governing what you can do with the ridgeline. And so layering an additional set of state regulations on top of that seems that it's likely to create confusion and ambiguity going forward. So, but I do think Rick is right in saying that the most recent draft of the Board of Forestry regulations is much better than the one that we saw 2 years ago, or whenever that in November when we got that first set. And I think people will be able to work with it, but some of the issues that we talked about, the small wineries getting stuck having to make improvements to private roads, those kinds of things will continue to trip up some applicants. So good slide. There is a comment period. We can send you a copy of the current draft of the regulations if you'd like. We would encourage anyone who might be affected by the regulations to go ahead and submit an email comment to the Board of Forestry and let them know. There have been a bunch of stakeholder groups that have been very active. Some of our clients, we have a couple different groups that we know of that have been meeting with people from the Board of Forestry and working behind the scenes, and it has had an impact. And these regulations are not final yet, so there's still an opportunity to have additional impact. So I think if you think you might be affected, you should absolutely have something to say. And I see the comments saying new projects are having difficulty getting fire insurance. And yes, that is absolutely the case. We have had a number of clients who've had to look in with all sorts of unlikely providers, not the standard insurers that we've seen in the past. So, but it's not, I don't know that adoption of the Board of Forestry regulations is going to solve the insurance problem. I don't know that insurers are magically going to say, oh yes, now that there are new road regulations, all is good. So at any rate, I do think it's important to have public comment as well as comment from the legal community, because hearing from the constituents who are actually affected has an impact. And remember that this is a board that is largely political in the sense that they are appointed by the governor. So they sort of report directly to the governor. And so that makes them more, I think, in touch with the political side of things as opposed to the pure administrative side. So do we have questions? Margaret, do you want people to ask questions in the chat? I know there are some in the chat already.
This will conclude the presentation and we will stop recording and open it up for questions now. So if anyone would like to contact us, here's our individual contact information, but we will open the floor up for questions.